Good day. Federation right. This is the power that unions have to unite in local, regional, national, professional, or industrial federation. They must be represented by a General Assembly and a charter. There must be a union charter, a board of directors, and a union register, and they are free to draft their own law. Collective labor dispute. The strike. A strike is voluntary collective suspension of work. Strikes are employed in public service, that is, to in a branch of the social sector. When a collective dispute exists where work is suspended, the delegates or people from the strike are selected to present to employees with the reason. A request and 20 calendar days agreement can be reached which can be extended for another 20 days. If the federal persists on any of the requests, a record is kept with the agreement and remains different. Negotiation must have full power to enter into a sin agreement. When the requests are fully or partially agreed, the request will be signed and sent to the Ministry of Labor and Social Security. To submit the difference to the decision of an arbitrary tribunal and will have the using the following determination of the agreement. The strict committee is the representative responsibility for freeing information to working and employer suspension, illegal collective suspension of work. It is illegal when it involves public service, it is pursued purpose of that professional and economic on and if the direct agreement is not fulfilled. Arbitration. Submission to compulsory arbitration of collective labor disputes that arise in essential public service and that could not be resolved through disputes. Busing clause. Public service companies that are not depend on the state canon supply work with government permit and companies that are not public service may only do so with permission for the Minister of Labor and
Articles 353 to 418 of the Colombian Labour Code. Introduction. Objective of the presentation: to explain in summary the key points of Articles 353 to 418 of the Colombian Labour Code. General context: the Labor Code regulates the labor relationship between employers and employees in Colombia, promoting job stability, social security, and the fundamental rights of workers. Termination of the employment contract. Articles 353 to 363. Article 353. Concept of termination of the contract defines the cause for which an employment contract can be terminated, such as mutual agreement, expiration of the term, justifying dismissal, etc. Article 354. Termination by death of the worker. The employment contract can be terminated when the death of the worker and compensation must be provided to the beneficiaries. Article 355 Termination by mutual agreement. The contract can be terminated by mutual agreement between the employer and the employee, establishing the branch for such termination. Article 356 to 373 Cause of termination with or without a liability. These articles detail the cause of termination, including dismissal without just cause, dismissal with just cause, voluntary resignation, and the conditions for compensation for unjust dismissal. Settlement of a private contract. Articles 374 to 384. Articles 374 to 378. Settlement of social benefits. These articles establish how salary, severance pay, vacation, bonuses, and other benefits must be liquidated to the employee at the time of termination of the contract. Articles 379 to 384. Compensation for dismissal without just cause. These articles outline the compensation that employers must pay if they dismiss an employee without proper justification and the producers to follow. Dismissal and its conditions. Article 385 to 401. Article 385. Dismissal without just cause. The employer can dismiss the employee without just cause, but must pay compensation proportional to the time worked. Articles 386 to 388. Grounds for dismissal with just cause. This article describes situations in which the employer can dismiss the employee without indemnity, such as serious misconduct, disobedience, death, etc. Articles 389 to 401. Dismissal procedures and legal consequences. Regulates the procedures the employer must follow when dismissing an employee, including notifications and the worker's rights upon dismissal. Workers' rights in a specific case. Article 402 to 418. Article 402 to 406. Job stability. Protect workers in situations such as maternity, illness, and other circumstances that may jeopardize their employment. Article 418 to 418. Fundamental labor rights cover issues such as the right to unionize, protection against labor discrimination, respect for human dignity, vacation rights, and other inherent rights in the labor relationship. Conclusion. Importance of labor protection. These articles aim to ensure labor stability, protect workers' rights, and promote fairness in labor relationships. Employer and employer's responsibility. Both parties must be aware of their rights and duties under the labor code to prevent conflicts and ensure compliance with the law. Thank you.